Hi, I'm Jody with Our Broken Systems. I'm here tonight to discuss some things with IDOC and the effects that it's having on our men and women on the inside, mentally and emotionally, and a few other things. I am not sure if Andy's going to be joining me tonight or not, but I'm sure hoping so. Uh, This is a new streaming app I'm using, y'all, so please excuse me if I'm not sure what I'm doing with this. Yeah, I know, right? So we're going to keep trying this. Okay. Now we're going to see who's going to wants to join in on all of this. Like I said, this app is new, so it's kind of neat to see and to work with it. I've been trying for 3 days, get it right, and I'm hoping I can. Um, but we'll see. Okay, here, people. This is really neat. I'm about to play around with this some more, you guys. As I've said before, and I'll keep saying this. One, I don't want to race bait with anybody. Two, we're not downplaying any victims. They feel the way they feel, and that's all good. I am a victim of a violent crime myself, and so is my family. So we understand, and I am with someone who committed a felony murder. So we understand both sides of this coin here, and much love and respect to the families of the victims. I'll never downplay that because you guys feel how you feel. I'm here to try to even out the balance of the good and the bad. Not everybody that's incarcerated is there because they committed a crime. A lot of them are there due to the accountability law in our state, which is very ferocious, if you ask me, and the truth in sentencing law. I do have someone that's going to be calling me here in a little bit, and hopefully we can get some discussions on that and his perspective. Uh, any of you who's got family that's incarcerated, please reach out and talk. We, as a team together, can make a change. This is what our senators and our representatives need to see and to understand this concept. Um, you know, no vote Democrats, no vote Republicans. We hold their votes in our hands. It comes down to a lot of legislators promise a lot of stuff during campaign trail. Prison reforms. They're going to do this. They're going to help with this. But when they get into office, the bill gets pushed to a committee, and a lot of times it just lays there and dies because there's not enough attention to it. Their excuse is that they don't have the power. Well, yes, you guys do have the power. We, the people, you work for us. I feel that if you're not going to keep the promise that you've making while the campaign trail, helping to eliminate truth in sentencing and help eliminate mass incarceration in our great state, then I think we should hold our vote from you and find a legislator or representative, Senate, whoever, that is going to help us do this. and that includes the governor. It doesn't matter if you're Republican or if you're a Democrat. This goes for everybody. This affects all of us in this state. It's not about if you can do the time, don't do the crime, and all this and that. That is the most ridiculous saying, you guys. Like I said, a lot of them are in there because of accountability. And the ones that did do the crime are doing the time. They've done decades and decades, and now they're sitting there and rotting. And our great state is costing them billions of dollars a year to house them. A lot of you guys out here do not know that your taxes are going towards IDOC, billions of them a year, for them to have laundry soap, toilet paper, uh, soap, toothpaste. None of that is free in DOC. Nada. We are paying for it. Taxpayers are paying for it. And a lot of them are not even getting it. So therefore, we have to do better because not only we paying for it as taxpayers, but family who's got loved ones in there are also double paying. This is wrong on every level you can think of, especially if you're low income and or medium income and you're struggling as it is to hold your household down, and your dad, your brother, your sister, your cousin, or whatever's in there, and they call you and say, hey, $60 a month and state pay is not cutting it. I'm out of this and I'm out of that. Who you think helps buy this? Nothing is for free inside of IDOC, unto the contrary of what the popular belief of the American people think. It's not. Their cable's not free. They pay for that. So do we. Their tablets, we pay for that, not them. Their clothes that they wear, we pay for. Their state boots, their state coats, their gloves, their hats. Yep, we pay for that, not them. It ain't given to them. You taxpayers and we, the families, pay for that. Trust and believe. Look it up. You can look any of this up and research it. Uh, the news is only going to give you 10% truth, and the rest of it is a lie. So, therefore, I advise you all to educate yourself and to research. It's a knowledge is huge. If you got enough knowledge on you to do a lot, so we got a lot of different things going on at once, and it's just awesome. We need to really get together and talk about this. Oh, hold on a minute here, you guys. I'm trying to get them to come through, and it's not easy. Oh, this is crazy. It really is. Hello? Correctional center. You must listen to this entire message. This is crazy. Yeah, these here are some jinky things with these phones too that just amazes you that, things just don't go right. Accept this call, press 5. To refuse, well, and all future calls. Yeah, it's something else. Imagine that. Any other time, my phones work just fine, the whole 9 yards, and not once act crazy all the way around. Imagine that. Must be Mercury messing around with the planets. But as I was saying, the laws are so bogus in this state, and it's all about money, location, and time, and it's a money maker. When you guys are affecting all that, it does this. Hello, you have a free call from an individual. Call, press 2.
To accept this call, press 5. To refuse this call, hang up now. To block this call and all future calls, press 9. You may enter a selection now. This call will be recorded and subject to monitoring at any time. Thank you for using IC Solutions. You may begin speaking now. Recorded and subject to monitoring at any time.
Okay, hold on a minute here.
IC Solutions. You may begin speaking now.
Okay, now I got both of my guys on at the same time. Here, this is kind of weird. Okay, T, you want to start off and say who you are?
For me,
Yes.
my name is Cedric Park.
Where you at?
I'm in Correctional Center in Galesburg.
And do you want to say who you are? Out of Dix.
Yeah, my name is Mark and I'm a Correctional Center.
Okay. I've got Marcus and I've got Nedrick. Both are going to discuss on the policies of what's going on with them in both sides of this fence and whatnot. Marcus, I'm going to have you start out with what's going on and what you want to discuss. It's very important that these guys hear about it. Tiger, if you got anything to say, chime in. And all my people, I will answer you as I go and see what's going on with these guys. Here we go. Marcus, you got the floor.
Yeah, the articulation of my theory is somewhat complicated, but it is fairly simple if the listeners actually, do a little research to look into it. But every component of the legal theory that
the volume is the largest.
Oh, go ahead.
Okay. So every component of the legal theory that I want to address includes Public Acts 89-404 and 9592. It includes the Reedy and Wilson cases, truth in sentencing incentive grant, which is a federal statute, which is now, it used to be 43 U.S.C. Section 13704, but now it's codified as 34 U.S.C. Section 12104, as well as I would like to touch on special legislation prohibition under Article 4, Section 13 of the Illinois Constitution, parole MSR constitutional principles, and federal preemption. So, the listeners out there, you have to bear with me a little bit because all of this stuff ties into truth and sense, and I'll tell you how. I was convicted in 2004, so my legal theory doesn't depend on pre-1998 conviction. In fact, like I said, this is a 2004 conviction, so it's post 730 ILCS 53-6-3 amendments. And that's important that you understand that. But my argument challenges the constitutionality of the process by which Public Act 9592 was enacted. My claims are procedural and constitutional, not temporal. So, Public Act 9592 was enacted while the consolidated appeals of Reedy and Wilson were still pending in the Illinois Supreme Court, and while Public Act 89-404's constitutionality had not been decided by the Illinois Supreme Court and Reedy and Wilson. Now, this timeline matters because Public Act 89-404, which was enacted in 1995, was struck down in People v. Reedy. However, in People v. Wilson, from a different district, to the contrary, upheld that opposite result. Because the Reedy and Wilson appellate decisions conflicted, the Illinois Supreme Court accepted both cases for consolidated review. Now, this is where things get real important for the listener to actually pay attention to.
You hear me, Tiger?
Public Act 9592, there is unresolved appellate conflict. The Illinois Supreme Court had not decided the constitutionality of Public Act 89-404. The General Assembly was fully aware that the federal truth in sentencing incentive grants under what is now recodified as 34 U.S.C. Section 12104, a compliance deadline, to my understanding, was somewhere between mid to late 1998. To avoid losing federal funds, Illinois rushed to pass Public Act 9592. Now, my theory is that the enactment of Public Act 9592 violated the separation of powers because the legislature acted to preempt the Illinois Supreme Court's pending ruling. Due process rights because the legislature interfered with the state's right to appeal review and Wilson's right to petition the Illinois Supreme Court for review. Also, Article 4, Section 8 of the Illinois Constitution, which requires proper procedural sequence for legislation. So, in other words, this argument can be framed as the General Assembly enacted Public Act 9592 using a constitutionally defective process to satisfy federal funding requirements while judicial review was still unfolding. Now, it's also important to understand how Illinois passed Public Act 9592 specifically to appear compliant with federal truth and incentive grant criteria. Now, of course, as I told you previously, federal law, which was 42 U.S.C. Section 13703, which is now codified in 34 U.S.C. Section 14101, required truth and sentencing laws mandating offenders to serve at least 85% of their sentence. It also requires certification by the state that the law was valid, enforceable, and uniformly applicable. And that uniform is very important for us to actually remember that word, uniform, applicable. Now, if Public Act 8944 was unconstitutional, then Illinois had a valid truth and sentencing law in effect during the eligibility window between 1995 and 1999, yet still certified to the federal government that it needed. Thereby, they falsely claimed eligibility. They improperly received funds, and they enacted Public Act 9592 solely to retroactively appear compliant. Now, we can get off into this false claim activity, but I won't get into that now because that's a whole other ball game that's very serious. And if you take it there, then it can possibly screw up any direction that one may take to want to actually assert that specific claim. But it's important that we consider the legal basis of this federal statute. Because the federal statute requires a state to have a valid, operative, and enforceable truth and sentencing statute in order to receive funding. If Public Act 8944 was invalid, as the Supreme Court held, then Illinois lacked a valid truth and sentencing statute during the original incentive period. Any certification submitted to the federal government between 1995 and 1999 was false. And federal funds received were fraudulent payments. So, now that we have an understanding about that, I also want to touch on the 100% requirement. The 100% requirement violates the Illinois Constitution's prohibition on special legislation. Why does this matter? Well, because Article 4, Section 13 prohibits laws that target a distinct class, impose different punishments, or treat similarly situated offenders unequally. When you apply this theory, the 100% rule applies only to certain offenses inconsistently without a rational basis, based solely on compliance deadlines with a federal grant, not legitimate penological purpose. Because, once again, 34 U.S. Section 101 12101 defines Part 1 violent crimes. All Part 1 violent crimes are to receive at least 85%, not 100%. Thus, it is arbitrary classification based and unconstitutional special legislation. Now, to touch on 100% a little further, you have a United States Supreme Court case, Morris versus Brewer. Morris versus Brewer supports that parole MSR must be a part of, not tacked on, the sentence. Morris's core principles, as the U.S. Supreme Court head, parole is a part of the sentence structure. Parole presumes release prior to the expiration of the sentence. Parole MSR cannot extend beyond the judicially imposed term. So when we apply this standard, me as a person who was sentenced to 50 years at 100%, I am being forced to serve 100% of a 50-year sentence plus 3 years of MSR equals 53 years total, which equals 106% of the sentence imposed by the trial court. This violates Morrison due process, and it also violates Apprendi versus New Jersey, because additional time was not found by a jury. So, to bring this theory to a close, the 100% requirement is preempted by federal law. The federal law requirement 34 U.S.C. Section 12104 requires a state, and as I told you before, to ensure Part 1 violent crime offenders serve not less than 85% of their sentence. Part 1 violent crimes are defined in Section 34 U.S.C. Section 12101 as murder and non-negligent manslaughter, forcible rape, robbery, and aggravated assault as reported to the FBI for purposes of the Uniform Crime Reports. Illinois requires 100%. This means Illinois' 100% requirement is stricter than federal law. And federal law is the supreme law of the land. Illinois did not enact the law to advance public safety, but solely to ensure funds, because the federal statute sets the outer limits of acceptable truth and compliance. Illinois' harsher 100% rule is arguably preempted because it contradicts the legislative purpose of the federal scheme, which was standardization, uniformity, what was that word, and adoption of at least 85%, not 100%. Thus, Illinois exceeded the federal framework in a way that undermines federal purpose. So I know that was a lot, people, but everything fits together, and it's something that we really got to look into.
I appreciate your time and all that information there, Marcus. That was a lot. And it's good that these civilians out here know that, because it's going to make it easier for them to fight for their families and their loved ones and know what their rights are and what your guys' rights are. So it protects everybody in between and involved.
Right. Well, like I said, my name is Marcus Buchanan. I'm in Dixie Correctional Center. I'm easy to find, so if anybody want to get in and we develop a coalition, because it's not easy for us in here, and we do need help. So reach out, and I'm willing to discuss it further, and like I said, develop those coalitions so we can actually fight for what's right.
Amen. Thank you again, Marcus. And our time's up with you. And call me again later this evening.
All right, will do.
Thank you.
God bless and Godspeed, people. Bye-bye.
You too, babe. Bye. Okay, you guys, that was Marcus from Dix, and he's on the right track. Now I've got Tiger here. He might have to call back in. And,
What he said was, I wanted to add to that is the fact that they never paid the bill, even though it was declared to be all they did was change the number and put a new number on it, and then they slapped it back in the and back in our face. They never fixed it. Even when the courts told them that they had violated the constitutional rights of individuals who have been sentenced under, they never resolved the issues that were part of it. It just reiterated it, you know what I'm saying, and it's allowed to stick.
Right.
So,
that's what he was just discussing, and he'd been discussing with me for a couple weeks now about that. And he's got a lot going on there, and we're going to start bringing some awareness to this. And that's what Andy Williams was talking about also. A lot of people don't know their constitutional rights. They don't know that they're being violated, let alone your guys's. And as I was saying at the beginning of the video that you guys didn't get in on, everybody out here thinks that you guys get everything handed to you for free, and it's not even like that. So it's crazy and whatnot. So it's a hot mess all the way around.
Look, like just the basic things, you know what I'm saying, such as
I think we lost signal here. Give me a few minutes and I'll be back with these guys and we'll go from there. Thanks again, y'all, for joining, and hopefully I can figure this out more.